give me just one more minute to get things a little bit dialed in. Okay. Hi, Keith. Keith, if you want to join us, you need to create an account and log into your account on our Start Mata community through 805 Startups, and then you'll be able to join us on stage with your mic and camera optional. David, Boyne, if either of you would like to ask questions, raise your hand. I'll bring you up, and you can do that. We'll go one by one. To get us started, Jordan, how about you give an introduction and yeah, let us know what you're all about.
Sure, sounds good. Thanks, Gary. So, hi everyone. Jordan Becker here. I am an IP attorney and a registered patent attorney. And I do need to clarify the obligatory disclaimer that I am not the lawyer of anyone on this call or anyone listening to this. If we're recording it, I am a lawyer, but I'm not your lawyer, is what I'm saying. Although I'm giving some general education here, I'm not giving legal advice to anyone. So this is just general educational purposes. That being said, I'm happy to answer questions to help people understand IP law better, clear up any points of confusion. So a little bit about who I am, what I'm about. I started my career as a rocket scientist at McDonnell Douglas Space Systems. My undergraduate degree is in electrical engineering. I worked there for about 4 years on the flight termination system for the Delta II launch vehicle before going to law school. Went to law school at Pepperdine University in LA, and then moved up here to where I am now, Silicon Valley, and became a patent lawyer. And I've been doing that for 30 years now. So I focus on representing high-tech companies primarily. So that's a lot of software, some electronics, mechanical devices, optical devices. I'm pretty much industry agnostic, but I tend to do a lot of work in the areas of cybersecurity software, medical devices, some robotics work. After 30 years, I've pretty much patented every type of technology in almost any industry that touches on high tech at this point. So that's a little bit about me. And I should mention that primarily what I focus on is counseling clients on their IP strategies and fighting with the patent office to get them great patents. I draft the patent applications and send them to the patent office and then negotiate with the patent office to get the patents issued. That's my core business, basically. Um, so anyway, I guess we can go ahead with any questions or talking points.
Yeah, awesome. Yeah, so yeah, Keith, glad you're yeah in the system now. And if you'd like to, again, either use the chat to ask questions or raise your hand, and I can bring you up on stage. And then again, you can use your microphone and camera optional to engage to ask any questions you have. And also, don't be nervous if you don't have any specific questions. It may be really invaluable as an experience to just share with Jordan what you're working on and what sort of ideas you may have or active products and services that you're already working towards. Yeah, so free to raise those hands. In the
Yeah,
meantime,
and
yeah,
I
yeah.
may not be able to give specific advice. I mean, some high level, pointers I may be able to give, but we don't want anyone to disclose any of their confidential information, on this call. And so, uh, we want to keep it high level primarily. Or
Yeah, it'd
again,
actually be really interesting to hear you kind of expand on that. What would be like a good best practice for keeping it high level versus what would be some things that would get into the kind of like trade secrets or sensitive information.
well, it's a really good question. And so I would say that, if you have a company that has invented something, um, you want to avoid kind of giving out the secret sauce on this I would say live stream. You can kind of talk in general terms about, what it relates to, the industry that you're in, the overall problem that it solves, but don't really get into the details of the solution on this call. So I'm not going to be able to tell you for sure if you have something that's patentable, but I might be able to tell you if it's in an area that is, easy to patent or more difficult to patent, um, things like that. I would say that when in doubt, don't, in terms of disclosing it. I'm happy to set up one-on-one calls offline if there's any doubt about, whether you're disclosing something that's confidential.
Good heads up. Appreciate that. Yeah. Yeah, Keith, David, Boyan, if you guys want to, you can also again use the chat just to share what you got going on, your background, what you're working on. Okay, Boyan, I'm gonna bring you up. But yeah,
Hello, guys. Can you hear me?
yep,
Yeah,
Okay. Well, good. Again, as you said, I don't necessarily have a specific question to in terms of patenting and stuff like that. But that being said, I can talk a little bit about what I'm doing, and then you can basically give some feedback whether or not I should even be looking at patents. And since we're on the topic of patents, I can express my personal opinion about it, and we can have a discussion about that. Uh, in general, if my position is that if you have developed a technology that nobody else has, and nobody else has any clue how to do, uh, you can patent it, but my impression is that patent is as good effectively as good is the lawyer you're going to have and the money you're going to have to fight for that patent, because again, nothing literally stops anybody from extracting information from the patent application and doing it, and then it's up to you to effectively fight them. And yeah, it gives you a big strength to fight them, but again, you also have to have a fairly deep pocket. And unless you're a patent troll, that's not necessarily very easy to achieve. So I'm not convinced that patenting is necessarily the best way to protect IP. A much better approach is, if you can achieve it, is to keep the IP close to your chest and away from spying eyes, right? So patent, again, on one side, it allows you to claim ownership over the IP. On another side, it makes you more exposed because, again, I mean, you have to disclose at least fair amount of information in the application, and that information immediately becomes available for everybody else. And yeah, I mean, if you don't have the strength to fight them, yeah, I mean, it's all for grabs. Again, I would be interested to hear your position on that one. You're of course going to be probably talking on the opposite side, and that's very important for the discussion. So please uh, counter my argument here.
sure. Well, first, I want to say that I agree 100% with your statement that the strength of the patent you get depends upon the attorney that you use to get it for you. Um, a lot of people have the incorrect impression that getting a patent is a lot like filling out a form. It's not. It's more like drafting a complex contract. And so you need an attorney that not only understands the technology very well, but also has a pretty good legal mind. And that's difficult at best for people who are not patent lawyers to really know, um, just from talking to a patent attorney. But it's the kind of thing that a good patent attorney kind of knows the difference between good work product and bad work product. You know it when you see it. But yeah, it's you could get 20 different attorneys seeing the same invention, they will write 20 different patent applications for it. And out of those 20, maybe one or two of them will be excellent, one or two will be terrible, and everything else in between will be not too bad, pretty decent. Okay, it'll follow a typical bell curve, like many other things where high skill is involved. But now let me get to your point about whether patents are necessary or not. You know, your viewpoint is certainly, shared by some people, more than a few people. But I would say that it's a bit dangerous to conclude that patents are not necessary without really understanding the particular, nature of the subject matter involved. Now, you know your own subject matter, whatever you're working on, but to make that as a blanket statement is risky. The thing is, in many technologies and industries, even if you choose not to get patents, your competitors very likely will be getting patents. And so you are opening up yourself to an attack later on by competitors, not just not just trolls, excuse me, if you don't get patents and something to potentially fight back with. Another consideration is that investors almost universally expect you to take steps to protect technology with patents. They will almost always ask you if they have any sophistication at all, if you've at least applied for a provisional patent application. And if you haven't, put yourself in their shoes, right? If you were going to put your good money into some startup venture, would you do that if they didn't have a moat built around their castle, right? So you need to have some form of moat. Now, is trade secret good enough? It could be. Patents are not always the right answer. I'm a patent attorney, but more broadly, I'm an IP attorney. So what I do for my clients is what is best for my clients in my judgment based on my experience. Sometimes that's patents. For technology, I would say that more often than not, that is patents, but sometimes it's trade secret. And we have to look at a number of different factors to decide, is trade secret more appropriate or is patent more appropriate? One of the factors you would look at is how easy would it be for someone to detect infringement? How easy would it be for you to detect infringement by some third party using your invention? Okay? If it would be very difficult or very expensive to find out, like for example, you've got some code that you're putting in a satellite and you're launching it, and nobody can pull that satellite out of space and look at the code, right? That would be pretty much impossible. Maybe that's an instance where you keep a trade secret, but it depends on the specifics. Okay, so I will never say patents are always the answer, but I would say that for technology, they're usually the right answer, but there are exceptions. So, for example, AI is an area where there can be exceptions. For example, like in the training data and the training parameters used, if that's innovative, that might be something that no one could know what training data and parameters you're using, and you wouldn't know what anyone else is using, right? So you might want to keep that trade secret. But other aspects of it, might be reverse engineerable, and therefore you might actually want to patent it because it's going to be available to someone who wants it badly enough anyway. Okay, so these aren't all the factors. These are just some of the things we weigh. And there are other reasons you might want to get a patent. By the way, I mentioned investors. There's attracting top talent. So sophisticated software developers. Well, not just software and hardware engineers these days. When they move from company to company, they want to know that the company they're going to is a serious technology company. And I think many people like that will question whether their potential employer is a serious tech company if it hasn't taken steps to patent its patentable technology. Again, always exceptions. And so I'll shut up now because I've been talking a long time, and let someone else ask a question. And I hope that answered yours. If not, feel free to circle back with me at maybe later on in this live stream.
Sure, absolutely. And yeah, if there is somebody else, they can come. Other than that, I mean, I can continue with other things. But is there somebody else who wants to jump in?
Yeah, we got two people with hands raised. So yeah, we
Okay,
can
yeah, yeah.
yeah we
You
can
can, you can take me down now.
yeah we'll cycle. But that was good. That was a great starting point, I think. All right, cool. Let me swap out. Okay, Bob, you should have an invitation to join the stage now.
By the way, Gary, can everyone who's on the call or on the live stream hear the questions and answers, or is it just the people that you queue up?
Yeah, everyone. Yeah, it's a group. It's a group effort, but only the people on stage are able to use their camera and microphone to engage.
Gotcha.
Cool. And Keith, I'll get you. I'll get you next, or after Savalas.
Hi guys, I don't know if you can hear me here or see me.
You can
but
hear you.
Great. Okay. Well, I don't know if the camera's working, but at least you can hear me. So I have an open-ended question. So basically, an idea that I'm just looking for feedback on. So very much early stage idea. In universities, they have a lot of intellectual property. A lot of professors will develop IP, and then oftentimes it'll collect dust and not end up finding a licensee. So the idea is to create a kind of like a crowd equity funding for IP.
So Bob,
Yep.
let me stop you for just a moment because you may not have been on the beginning of the call. So for anyone who is not on the beginning of the call, I would say that I'm happy to give high level information, but don't disclose anything that you think is confidential to what you're working on this call, because we want to make sure we preserve that confidentiality you know
Sure.
for later on. So
Got it.
you can speak in general terms what you're working on, and I'll do my best to give you some guidance on that. But don't get into the details of what you think might be, innovative that you might want to protect.
Sure. Yeah. So I mean, it's basically the idea is for a platform. So there's nothing confidential about that. But I was just curious what your thoughts would be about individuals getting access to fractionally owned university IP and universities benefiting from being able to get market feedback from the wisdom of the crowds instead of having to approach licensees one by one, more of a shotgun approach as it's currently done. So just, yeah, open-ended feedback on this idea before I get too carried away with it.
Maybe you can just repeat that one more time. And I'm sorry, I'm not sure I fully absorbed it. So individuals getting fractional access to university-owned IP, is that?
Exactly. Yeah. So like maybe a university might give up 5% of rights to a certain invention through some provisional patent they filed or full patent application they filed, and then individuals could bid on that 5% in fractional shares. So basically, it's like owning shares of that IP before it's licensed, and then once it's licensed, they would benefit from it. So it's like a way to get some more early traction on IP instead of it just sitting around waiting for a licensee to appear.
Well, I hate to give like a purely lawyer-like answer, but it depends. Um, it really depends on the specifics. The devil's in the details, as they say. And so, I could see that some a relationship like that could be beneficial to a lot of companies and individuals. But it depends on what's in the actual agreement, in the fine print, so to speak. And part of the value of a patent is the exclusivity that it brings to the patent owner. And so when you have a fractional interest in it, I am not sure you would have that exclusivity. I mean, it's not clear to me whether you're getting just a fractional right to the proceeds, but somebody else, the university in particular, has full control of enforcement of the rights, and you're just a passive investor, or if you have some control over that. But I think there are a lot of variables here that make it really difficult, if not impossible, to say that yes, it's a good thing, or no, it's a bad thing. I think it could be either, depending on the circumstances. And
Okay.
knowing more about the specific situation, I might be able to give more concrete advice.
Have you heard of anything similar to this ever being developed, or any leads that I may need to look into as similar stuff that, or like-minded people that maybe are interested in such things?
I have not heard of anyone doing that.
Okay.
I posted a link in chat to an individual, Jim Winnett. He has a firm that looks at university IP and tries to find hidden gems to commercialize. Yeah,
Great.
Jordan, if you've heard of anyone else that has firms like that, that would be interesting. I'm curious, like, in your experience, what, like, what's the process of trying to commercialize that IP that universities produce that often just collects dust?
Yeah, I mean it's not an easy process, really. I mean this is really more of a business question to me than an IP law question. And I hate to punt on this, but I believe it's really what it is. I mean, commercializing any idea is a business process. You have to have the right team, and you have to have an addressable market, um, and you have to put those together in the right way. And securing the IP rights is, I think, secondary to that. Um, so, yeah, sorry, I can't give you a better answer on that.
Thanks. No, I think that was helpful. Thank you, guys.
Awesome. Cool. All right. Yeah. If you have follow-up questions, feel free to use the chat or raise your hand again. In the meantime, I'm gonna bring up Savalis. All right, Savalis should have an invitation now. And yeah, for those that are joining us, feel free to use the chat to ask questions, to ongoing conversations, or inform me that you want to be brought up on stage if you can't figure out how to raise your hand. But you can raise your hand and then I'll bring you up.
What's that?
No, you're good. You're good.
Oh, okay, okay,
Yeah,
okay.
yeah.
I'm not sure if I'm allowed to share my screen, so I'll just share. Am I allowed to share my screen? I'll just share the patent info here, right here. This is a patent that I filed for a while back.
So
And
I don't know about anyone else, but I cannot see anything you're sharing.
He posted in chat a link to a Google
Okay, I
link.
got it
Yeah.
now.
okay,
Okay, and now I see it.
okay. So and then and I can share it right here too. Okay, you see this right here. So I realized that the patent was been cited by Nintendo and some other companies. Nintendo, you see right here, and then several other companies. So my
So
understanding.
you're showing me the patent here. Yeah, okay, got it. Okay.
Oh, you
Cited
got
by
it.
Nintendo.
Okay, cool,
Yeah.
cool. So these are the different citations. So I guess this means that I filed other people from blocking certain claims in it. I'm not quite sure, but I filed it a while back, and it was I abandoned it. And I was wondering if there's anything that I can pick up, like some claims that I've had. If I can go back and refile, what can I do to salvage?
Right. So first of all, what the cited by means is that the patent office has cited your patent application against somebody else's patent application, um, generally in a rejection. Um, that doesn't mean that they couldn't get a patent or didn't get a patent, because almost every patent application is rejected at least once before it becomes a patent. So,
Mhm.
and sometimes um, patents and patent applications are cited just as relevant art, but not in a rejection, just
Right.
as background art. So it doesn't mean a whole lot. However, if your patent application was cited against many different patent applications, that could be an indication that the examiner considered it to be, quite relevant in a particular technology area and may have something, quite innovative in it. And there are some software tools commercially available, some of which my firm has, that can actually tell you how many, of those citations have occurred. So
Mhm.
that's a little background on what cited by means.
Okay.
Now, in terms of reviving a patent application, there are ways you can revive an abandoned patent application, but it is not automatic. So you can, if you can show that you unintentionally abandoned it within, a certain, let's see, when did this one,
It, it
when
was back in 2004.
you would have a very hard time reviving this one for unintentional abandonment. I would never say never. Um, you can also um, revive potentially based upon unavoidable abandonment, meaning there were some circumstances that there's just no possible way you could avoid it. Um, Generally, making a decision that you didn't want to spend the money is not gonna work in either case. Um, and the more time that goes by, the harder it will be. So I would say that I won't say it's going to be impossible to revive this, but uh, the odds would be against you on this. And I would be happy to discuss it more offline. Again, I can't give specific legal advice,
Mhm.
and you may want to seek a second opinion on it from another patent attorney as well.
Okay. But there are no numbers or no time frames other than like, I know it's been like, what, 20 years?
So well, that's another good point. Actually, the term of a patent is 20 years, right? So from the earliest filing date. So at this point, you've run out of term, and yeah, I actually should have picked up on that immediately. Um, so there really wouldn't be any point in reviving it.
Okay. Okay. Unless I pick out certain pieces that maybe they have missed, I can probably refile, right?
Um, well, I mean, it's all public information now. So your publication is prior art to anything you would now try to refile, anything that's
Oh,
discussed in the published patent application.
oh, my
Right, so you're
own.
not going to be able to patent anything that's in this publication.
Okay. Okay. Great. Well, thank you. Thanks so much. That was informative. I just have one more question. Is that okay? It's not related to this patent. It's related to another invention I have.
Yeah, feel free to ask.
So um, I invented this. It was about 4 years ago, and I had this made in. I think I mentioned it before. I had this made, Gary. I believe I mentioned it before that I had this made in China, and I had it produced there. And now I see something that looks very similar after a year that I've had it out in Alibaba. And I know there's some issues with. I mean, they copied my design, and then I actually told the company about it as well. So I don't know. There's nothing I can do with as foreign, right?
Well, if they're selling it only in China, then to stop that, then you have to have a patent in China. Um,
Right.
so, I mean, if they were importing it into the US, then if you had a US patent, you could then do something about that.
Hmm.
But patents are country specific. So if
Right.
the infringing activity is happening only in a specific country, then you have to have a patent in that country to
Right.
assert patent rights.
Right. Okay. Right. Cool. Thanks. That's pretty much what I want to ask. Cool. That cleared up some things. Did you have contact information on here? I can get that later.
Yeah, let me pop that into the chat here.
It's also shared on the event page as well, just for everyone's knowledge. But yes, feel free to use the chat.
Okay.
Yeah, I'm also on LinkedIn, Jordan Becker.
Oh, definitely. I'll share. Oh, yeah. I'll send a connection on LinkedIn then. That'd be a lot easier. Yeah. Thank you.
Cool. Mhm.
Bob has a follow-up question. He's asking, can he try to purchase one via Alibaba, and if they ship it to him, it's proof they're infringing?
That's good.
Can you try to purchase one via Alibaba? Um, yeah, but if you don't have a patent, it's not going to do you any good. That's the point.
Yeah, because it wouldn't be infringement at that stage, right?
Well, there's nothing to infringe. I mean, there's no patent, as far as I understand it.
Hmm. Yeah, I just had a provisional for it, but that's only a short while. I can probably recover that one, but okay.
Yeah, and you've got
Those are
1 year from the provisional filing date to file a non-provisional. So, here's a misconception, right? People often talk to me about their provisional patents. There's no such thing as a provisional patent. There's only a provisional patent application,
right.
right? It
PPA.
never becomes a patent. You have to file a non-provisional application within 1 year, and then the non-provisional application can become a patent after it's examined. That the provisional application just sits there for a year, doesn't get examined, and it dies after a year.
Thank you.
Right on. Cool.
Right
Yeah,
on.
appreciate the insights. All right, I'm gonna bring up Keith next. All right, Keith, you should have an invitation.
How did that go? Is my microphone?
Yeah, Mike's working.
No camera. Sorry about that. All right. Hey, Jordan, thank you for volunteering your time. I appreciate the spirit there.
Sure.
My background is a product person in software startups, and I've got a question kind of adjacent to trademark, and maybe even the crowd might be able to help with this. Um, I've been unsuccessful with ever making a trademark claim on Twitter usernames, been down that rabbit hole and kind of get the dormant account and all that. I'm wondering if there's been any change with, the footprint of Twitter and less bodies in the office, if this has become more possible, or is it still just very, very hard, if you or anyone else is aware. My literal is the account that I'm interested in with overlap for my brand, my domain name, etc. Is the 2013 account with no posts and one follower. So in my head, it's abandoned, but it's been a no so far, and I'm just wondering if things have changed to Twitter.
Yeah, I got to be honest. I don't do a whole lot of trademark work. I mean, in terms of filings. So, I can give you advice on the high level, like the kind of things that are protectable versus trademark in general. But I can't say that I've had that experience. I can connect you with somebody that can advise you on that. Sorry.
Yep, totally understand. The invite caught my eye, so I get that it was a little bit more adjacent than spot on. Thank you.
I'm
Yeah.
curious as like a point of discussion when we're talking about like trademarks and just generalities of their purpose and what the law protects and how that relates to like a user handle on a social network, right? Like if the user handle isn't operating within that same market in a way that's causing confusion, would trademark even come into play?
Maybe you can clarify your question a little bit.
Yeah,
So,
so my understanding, and you can correct me, like, trademark law is meant to prevent confusion in the marketplace. So
well,
you
a
often
trademark is meant to protect the source of the goods, right? A trademark identifies the source of the goods or the services. So you're correct that to infringe a trademark, there has to be likelihood of confusion on the part of the consumer as to the source of the goods or the services, right? So to that extent, if a trademark handle is being used in a manner that's not creating a likelihood of confusion, for example, it's not being used in connection with marketing goods or services, then there's no infringement of trademark. Is that what you were asking?
yeah, exactly. And yeah, thank you for clarifying what I'm trying to get at. Yeah. Yeah.
Yeah.
So yeah,
Yeah,
that's what I
because
was,
I mean, the
yeah.
point is the infringement of a trademark occurs when you have a use of the mark in commerce, right? And so by just using it as a Twitter handle, you're not necessarily using it in commerce.
Yep. I put some links and comments in chat that might be of interest to if other folks are interested. Cool. Again, thank you. I was kind of expecting a little bit of a rain cloud, but I
Yeah.
haven't made a commitment on a brand and domain name and all that. So just trying to get out in front of it and getting everything aligned.
So I'm happy to hear these questions and do my best to answer, but just like to give you, for anyone who joined late, because I gave a little bit on my background at the beginning. So I'm a patent lawyer primarily, but I'm not just a one tool guy. So, I don't just rubber stamp, come to me, okay, we're going to try to get you a patent. So usually the issues that I'm dealing with are patent and trade secret, right? Because it's usually one or the other or a combination of those two for a given product or system. I can give high level advice on copyrights, and I have and sometimes do apply for registration for copyrights, and high level advice on trademarks. But when we start getting to specific fact scenarios and stuff like trademarks, I may have to beg off on that.
Cool. Understandable as well. So yeah, if anyone has like any additional comments, questions, feel free to use the chat, raise your hand. Yeah. Keith, if you have anything else like, related to patents or trade secrets, you're curious about, feel free to ask.
And if not, I can go through a few common myths about IP, that I often hear, if anyone is interested, or if not, that's fine too.
Yeah, let's do that. Keith, I'll move you back down. If you have follow-up stuff, you can always come back.
Thank you.
Yeah, cool. All right. Yeah. All right. Jordan, educate us.
So let me put up a slideshow here. Hold on a second. Okay, so where's the sharing icon on this interface? Oh, here we go. Share screen. Give me 1 second while I find the right app to share. Here we go. All right, slideshow. Can everyone see this slide?
Yeah, we're live.
All right, so this is part of a whole presentation that I give from time to time, but I wanted to talk about this because some people have the mistaken impression that once you have a patent, you're free to make or sell your product. Not the case, and here's why. Right, so this is the state of the art, right? Surrounding you've got an invention, right? And these red circles are what we call in the profession the prior art. Just means the state of the art. And now you've got some novel product.
1 second, Jordan. We're still looking at the slide 13, mistake number 4. We're not looking at the circles yet.
You're looking at slide 13. Okay.
Yeah, we see the whole layout of the slide of the PowerPoint. So,
Oh, that's weird. I wonder why that's happening.
Good old technical issues.
Yeah, I wish I knew why that was happening. So, what are you still seeing right now?
We see where your mouse cursor is on. Yeah. So now it just we're looking at where your mouse cursor is still, but now it's showing us slide 14, state of the art.
Okay, good. I mean, maybe I'll just stick on this view then for now, since you can see it as long as it's fairly visible.
Yeah,
right?
yeah.
So these red state of the art, and then you come up with this invention, the green circle, and you decide you want to patent it. You don't have to, but supposing you do, okay, you go to a patent attorney and they give you coverage that is as broad as it can be under the law, which is this lighter green circle. So it's just bumping up against the prior art. So you notice that's the power of a patent, by the way, is the protection offered by the patent is actually broader than the implementation, which is your product. Okay? That's where the skill of a patent attorney comes in, is making the language in the patent broad enough to cover something, that just bumps up against the prior art but doesn't overlap it. Here's the problem, right? This is not allowed. If your patent overlaps the prior art, it's invalid. So you want to avoid that. Now, again, my point was, if you have a patent, does that mean you automatically can make and sell your product? No. And here, so this is the goal, but here's why you can't automatically sell it just because you have a patent. Okay. Well, now I'm still getting ahead of myself. This is what you want. Your patent covers your competitor's product, competitor A. Okay. Here's the problem. Competitor B may have a patent that predates your product, that covers your product. Okay. Give you an example. Let's say you're the first person that invents, let's say, a bicycle that has 2 seats on it, and so you patent it. But somebody else has a patent on just the bicycle, right? That covers a 2-wheeled vehicle with a seat, right? Well, you're making a 2-wheeled vehicle with a seat, 2 seats actually, but under the patent law, it's the same. So you're infringing their patent. So the fact that you get a patent doesn't automatically mean you can make or use your invention. Does that make sense?
Yeah, and it clarified the previous art circles and where that would, expand and infringe on that. Yeah.
Now, does that mean you shouldn't get a patent? Hell no, because there may be plenty of other people out there who are infringing your patent, and they, you know, may come after you with their patents, and you want to have something to fight back with. So there are plenty of reasons to still get a patent, even though that's not the purpose of a patent, is to give you the right to make and use the patented invention. The purpose of a patent is to give you the right to stop somebody else from doing that.
Bob actually asked a really interesting question that kind of relates to this too. It's in chat. I have a question. What is your biggest success story in helping a patent get to a licensing deal? And what were the key things that enabled it?
Well, in terms of licensing deals, so I don't typically do licensing deals, but I get patents from my clients. And I'll give you an example of something that I've been working on here. Hold on one second. This is one of the few inventions that I actually keep in my desk drawer. I'm going to show it to you in a second, because it's one of the few things that's small enough to keep in my desk drawer. This is called a pillbot. This is a robot that you swallow, and it's made by a company called Endiatics, which I represent, and the purpose is to get rid of endoscopy. Now, if you're not familiar, endoscopy is where you swallow an endoscope, basically, so a doctor can image the inside of your stomach. And it's the equivalent of swallowing a garden hose. And so my client, Endiatics, came to me in 2019 as a young startup. They had almost no money and no patents, no protected IP, with this idea. Long story short, we've now gotten them a bunch of patents, just secured their Series A funding round for multiple millions, based largely on a valuation that is based on their IP. So, that's one success story. This is still going through FDA trials, by the way. You basically swallow this with some water. You sit on your sofa at home watching Netflix while the doctor is somewhere across the country using an Xbox controller to steer this around in your stomach. If you're interested in seeing a demo, go to endiatics.com and you'll find the demo there. As another example, I've worked on tons of patents for Intel Corporation on many different aspects of semiconductor fabrication and software as well. So, in terms of the licensing deals, there are IP specialists that do nothing but licensing. That is a specialization of a specialization. So I can't say that I have done licensing deals. I would hand that off to a licensing specialist. But um, also a number of the patents that I've written for a company called Open Wave System and telecom area have been enforced for a fairly decent amount of money. Um, so a few success stories there. I think the biggest form of success that I get that sticks in my memory is when I work with startup companies and I'm able to help them get funding based upon getting the IP secured. It's not that frequent that any patent owner actually enforces their patents. It happens, and sometimes it's worth mega millions of dollars, but I'd say more frequently the patents are useful in attracting investors and giving them the confidence to put their money into the company.
No, that totally makes sense, and it kind of speaks to what a lot of investors are looking for is the the ability for founders to execute and be aware of what the risks are and how to manage those risks. And yeah, so that totally makes sense. And I'm a big fan of that pill, by the way. I think I've had 5 endoscopies, and it's never a fun experience. Like even going to sleep and waking up is you're very 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 sore for a while. So yeah, I appreciate that invention big time.
Yeah, I've been through it as well, and it's not fun even under sedation. But um, when this thing gets approved by FDA, I think it's going to really revolutionize that uh, that type of medical practice. And um, you know, so anyway,
Yeah,
on to
I'm still blown away by the doctor controlling it with the Xbox controller. Very cool. A couple things in the chat. Bob says, "Thanks for sharing. Always nice to see tangible examples such as physical products and helping a startup to gain funding from investors." Awesome. Savalas says, "How much experience does your firm have with patents involving generative AI and hardware integration? Would this fall under a design or utility classification? Would it be necessary to file two separate patents?"
okay, so we have tons of experience with patenting AI. I've been patenting AI for more than 20 years. Um, a lot of people, think that AI is a new thing. Probably nobody on this call thinks that, but a lot of people do, because of ChatGPT and generative AI in general. But discriminative AI has been around for decades, and I started patenting that many years ago, and have been patenting generative AI inventions more recently. We've got lots of experience with AI, me and my team. So let's see your questions then. Oh, design or utility. This would be utility. So design patents are used to protect the visual appearance of something, which usually is a physical product, although it can be a user interface like a GUI screen or a series of GUI screens or an animation or icons if they're novel. Um, those are potentially protectable with design patents, but anything where the functionality is what's key, you would use a utility patent to protect. Uh, and so would you file two separate patents? Yeah, I mean, if you could have a product where both design patent and utility patent are appropriate, so they would be separate. Where the physical appearance is novel and valuable, and where the functionality is novel and valuable.
Yeah, I brought you back up, Savalas, so you can continue the discussion.
Oh, okay. I was just listening. I went to.
Yeah, well, you added a little bit more context in regards to it being physical as well and hardware. And yeah, if you want to expand a little bit more in regards to how those connect, feel free.
Oh, okay, yeah. I won't go be specific, but yeah. So yeah, I've been in AI since '94 actually, um, around that time, and been focusing on it now. This is related to a generative piece, but also medical and hardware and the integration between the two. So I'm wondering like it's pretty much a consolidated piece, one controlling the other actually. So that's all I can actually say about it on this call. But yeah, that was the genesis. That's what my question is in regards to.
Yeah, and hopefully the answer was clear. And if not, I'm happy to clarify. But so you could actually have multiple patents on the functionality and the structure, multiple utility patents, for example. So you could potentially have a patent on the mechanical structure of it if there's something novel about it that's valuable, and then another
Okay.
patent on the software. The electronics. Um, you can start by piling everything into one utility patent application and then claiming all of that together if you want to. The patent office is ultimately going to tell you to just pick one part of that, and then the rest you can file divisional applications for, and you'll still get your original filing date. So whether you start by piling everything into one patent application or whether you start by filing separate patent applications, there's not a huge difference. I mean, there can be some cost optimization that's done. That depends upon the specifics of it.
Did you say divisional or provisional?
Divisional.
Okay, that makes
Right. A
more sense.
divisional application is when the patent office says you've got more than one invention that you're claiming, you have to pick one, right? So you do, and then you optionally can file a divisional application or multiple divisional applications for any other invention or inventions that you didn't pick.
Okay, and just a follow up. Well, not really a follow up question, but a separate question. The mayor of LA now, Karen Bass. She was, I believe, was commissioner before. She had formed a group with the chief of staff of, I believe, it was the patent office, and brought a group of us in, and we were talking more about software patents. Now, have that changed over the years? This was about 10 years ago. Because I mean, my main complaint before was that, okay, if we're going to share everything through the patent application as software and it's not going to be encrypted, I haven't followed up on it. I haven't been following anything. Has anything changed so that you don't have to share all of your software?
You've never had to share your software to patent it. That's
Really?
never been the case. Really.
Just the executable?
You don't have to share any of your code to patent it. You might be thinking of copyright. When you copyright code, to register the copyright in your code, you have to submit a sample of the code. And typically that's first and last 50 lines of code, or it can be a segment in the middle. It depends on the circumstances, but it's usually a pretty small fragment of the code. That's to register copyright, which generally you don't even have to register copyright unless you're going to sue somebody for infringement. Copyright protection is automatic once you've stored it in a non-volatile memory, or a flash drive or something like that. But for patenting, you do not have to disclose any code. You never did, and I would almost never do that. It's not wise to disclose your code in a patent application. Instead, you describe it in terms of algorithms using flowcharts and schematic diagrams.
Okay, so just a schematic. Okay, see, my understanding back then, I mean, it wasn't copyrights I was talking about; it was patents. And my understanding was that I had to share my code, and it's just the schematics and explaining what the algorithms are and what they do.
Yeah, I mean, typically it's flowcharts, which is ironic, right? Because no software developer uses flowcharts, as far as I know.
No, actually we do. We do. I mean, just like flow. Yeah, there's some
Okay.
flowchart. Yeah, it happens.
Okay. Well, I mean, then that's fine. Then that's perfect. You can
I mean, I hack
adapt
everything in
those.
my life, but it's flowcharts come in there somewhere. But thank you.
Okay.
Thanks so much. Yeah, I basically sent an invite over LinkedIn.
Yeah, but what I would say is that you would never want to use flowcharts that are at the code level, right?
Right.
You would use, at best pseudocode, but really plain English, like putting the steps that the software executes into plain English language um, is the way to do it when you apply for a patent.
Okay. Cool. Thank you. Thanks so much. Yeah, that's very helpful, and that actually relieves me a little bit too. So that's good. Thank you.
Right on. Cool. Thanks. I'll move you back down. We're coming up on time. Hang on one second.
Wow, that went fast.
Yeah, it's been a great group. Really interesting questions and yeah, great insights. I'm curious, just before we head out, speaking more from like a career side of things, for people that may want to pursue a similar career path as you, what are some tips that you would give them in terms of uh, having the easiest time to achieve that ambition while not skipping steps, if that makes sense? You know what I mean? Like, still put in the right work and develop their skills and their expertise and their connections and relationships within the community to get them where they need to go, but in the easiest way possible.
You may not like this answer, but I would never advise anyone to take the easy path. Um, Anything in life that's worth something is worth working hard for. And usually, when you try to do things the easy way, you get out of it what you put into it. And I don't mean to be condescending about that. And I didn't always think that way. That's something I learned from life experience. Um, but so if you're asking me like, what's the easiest way to be a patent attorney without skipping steps? Maybe maybe a better maybe what you really meant was what's the most direct way to do it.
Yeah,
Um,
more direct, efficient. Yeah, there's better use of language. See, this is where being a lawyer is coming in handy.
and I don't mean to pick on you, Gary, um, but you do need to have a technical or hard science background to be a patent attorney. To be allowed to take the patent bar exam, which is separate from the state bar exam. Um, so, like an engineering background or physics, software, computer science, those would qualify. Biology, chemistry, those would qualify as well. Um, so you need to have that background. And then, it's always good. I mean, law firms like to hire people that have had at least some industry experience before becoming a lawyer, ideally. Um, so, I mean, I had a few years experience, as an engineer before I went to law school. That's, the best way to do it, but you don't have to. I mean, you could go to law school right out of, your technical degree and then go to work as a patent lawyer. Or you could become a patent agent if you have a technical background by simply taking and passing the patent bar exam without being a lawyer. The difference is you would not be able to counsel clients about litigation and enforcement issues. You could only represent them before the patent office. So you wouldn't have, as complete a skill set as a lawyer does as a patent agent. Um, but for somebody that, has a technical degree, really likes patents, wants to get involved with patents, but doesn't want to go to law school for 3 years, then becoming a patent agent might be a good option. You could get hired by, a lot of law firms and some, companies.
Right on. That's cool. It's good to,
You
yeah,
have to
again.
really like language, though, to do what I do or to be a patent agent. Either way, you have to have a strong technical background and really like playing with words in a way that helps solve problems for people in a legal sense.
Yeah, I mean, going back to your slideshow, that is very well demonstrated in regards to crafting the patent appropriately. So you fall within that sweet uh, 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 area of not encroaching on existing art, but still being as protective as possible of what the patent's meant for. So yeah, makes sense.
Yeah, yeah. Well, anyway, glad I could help, clear things up. So hope this was somewhat helpful.
No, this has been fantastic. Yeah, again, we're new at this, and it's been one of the biggest groups that we've had. So, I deeply appreciate your time and effort to help us grow the community and help people that exist in it. If you
Yeah,
have
and I want
any,
to thank everyone on the call, by the way, for all the really good questions, thought-provoking questions. I really appreciate it. And I want to thank you, Gary, for putting on this event.
awesome. Yeah, I appreciate that too. Any closing statements, final thoughts, announcements you want to throw out into the community?
No, it's been fun. I think people have my contact information, but again, I'm on LinkedIn, Jordan Becker, and my email is jbecker@perkinscoie.com. I also have a podcast called the Tech Law Hangout that talks about the intersection between law and technology. I talk about a lot of IP issues. And I have some guests on that talk about different areas of law that impact technology companies. So check that out, the Tech Law Hangout. You can get it on Apple Podcast and Spotify and other places.
I'm looking for the link right now so I can drop it real quick in the chat. Nice. I love that it's on Spotify too. And I'm sure there's probably a lot of good content on the way with all the new stuff happening across the board. But yeah, awesome. Appreciate that. And we'd love to have you back. But yeah, I'll follow up with you later. And with that, we're at the end. So thank you so much for, again, being a great mentor.
Thanks, everyone.
All right. Take